6 days ago, I was meeting with the Red Lake Band, the Leech Lake Band, and the White Earth Band of the Ojibwe Chippewa. And it was my pleasure to be able to speak about Lafayette for the training that we did there. The main reason I bring that up is that it was -8 degrees in Minnesota when I was there one night. And so I think I've had a 90-degree swing between there and here. So I have a little bit of a cold. So I apologize for that, but we'll make do. So I wish I could say that the experience of other communities across the United States is different than the experience that you have here. I wish I could say it's just a difference in who you elect. I wish I could say it's just the difference in who's in charge of the policy levers within particular governments, but it's not. It's actually a structural issue, because in these other communities where we work, they run into the same hurdles, and it's because you live under the same system of law. And in fact, the structure of law that keeps you from saying no to certain dangerous things that come into your community, that are proposed for your community, actually is trackable all the way back to the DNA of how this country has been built. So all the way back to the constitutional stuff. It's why when Cliff talks about the first thing that you ran into was not the corporation or the trade association, it's your own system of law that you run into that divests you of the authority to actually say no to certain dangerous things coming into your community. It took us 15 years to get to that conclusion. As a law firm, it took us 15 years to come to that conclusion. And so in the beginning, we didn't come out of the gate, out of law school, saying, hey, there's this structural issue, it's systemic. We need some kind of very basic change in this country so that communities have any degree of self-government, because that's what we're talking about. When you say no to a pipeline coming through your community, or say no to fracking, or say no to big box stores or factory farms, we're talking about your right to self-determine, your right of self-government in the place where you live. Because if you don't have that right, then somebody else does. And in many cases, it's the corporations that come in to actually make decisions on your behalf in the communities in which you live. So over 20 years ago, we were created as a law firm, the Community Environmental Legal Defense Fund, to provide free legal services to conservation-oriented community groups. We thought that the answers lie within the current conventional system. That if you wanted to say no to a project, that you had the leeway to do so within the existing system. And so at one point we were representing about 300 citizen community groups across the state of Pennsylvania, which is where we got our start. And those groups all had one common denominator. They were basically neighborhood groups, community organizations, 5 or 6 people that came together that said, we want to stop a toxic waste incinerator that's coming into our community, or a factory farm, or one of these other thousands of different single issue projects that we encounter in these communities every day and every week across the United States. And when those folks would call us to obtain our services, they would say, we don't want this factory farm, or we don't want this frack well, or we don't want this facility in our community, because our definition of sustainability doesn't include a 20,000 head hog factory farm in the middle of our community. And we would say to them, you know, we're with you philosophically. I wouldn't want to live next to a 20,000 head hog factory farm either in my community. But unfortunately, the system of law bans you from prohibiting any legal use. And this is usually where our democracy schools take off, these 3-day trainings that we do, because most people aren't aware that that's law, that that's embedded within the structure of law. But if a facility or a project or a proposal has been permitted by the state or federal government, in other words, it's a legal use, that communities are banned from prohibiting that use. So if something's been deemed to be a legal use, communities in the United States are banned from prohibiting that use. Now, this isn't, you know, Pandora's box that I'm opening up here. You ask a corporate lawyer, you ask an environmental lawyer, they're all in agreement on one thing, which is that is the law in the United States today. And it's been that way for about 150 years, that communities have been constrained from actually banning certain uses that have been permitted by other levels of government. And the reason for that, of course, is that when something's permitted by the other levels of government, it's deemed to be safe. It's deemed to be okay. It's deemed to be permissible. It's deemed to be legal. And so there's no reason for a community to have a veto power over that project because something's already been deemed to be safe and legal by the authorities and the agencies that have resources to look into those things and all that kind of stuff. And so that's been the law for the last 150 years. When we would get phone calls from communities in Pennsylvania asking for help, we had to explain that to them. We'd say, philosophically, we're with you. I wouldn't want that facility in my community either. But unfortunately, in the United States, you're under a system of law in which you can't ban that facility or proposal. And they would say, okay, what do we do next? And we'd say, we're so happy you asked, because we're environmental lawyers and it's what we do. And what environmental lawyers do today, as they did before, was appeal permits. So permits been issued by the state or federal government to the corporation that's putting in the facility. And the job of environmental lawyers is to take the environmental regulations that have been written to govern the issuance of that permit and the permit application itself, which is sometimes thousands of pages long that the corporation submits, and compare the two and figure out what's missing. Gaps, omissions, deficiencies in the permit application that the regulations are required to be in the permit application. Given that 90% of all permits in the United States are not appealed because the communities don't have the resources to actually appeal them, that sometimes just by showing up is enough to win those permit appeals. And so we showed up and we won a bunch of permit appeals. In fact, almost all the ones that we filed, we won. So we had a win-loss record of like 302, something like that. The unfortunate part is folks that have been through the permit appeal process understand is that as soon as we found a gap or omission or deficiency in the permit application, like somebody had signed the wrong place, or the wrong corporate official had signed here, or a bond was given but it wasn't enough, or there was an old macroinvertebrate water study that was 10 years old, should have been 5 years old. Those types of things are what we look for. So we're in front of a judge arguing, Your Honor, under section little 2, little c, little d, little 2, little Roman numeral e, little 2, little c, little d, that the secretary signed the application but not the president, which was required under the regulations. And the judge would say, you're right. And he or she would overturn the permit. The community group would then have a victory party. We'd go back to their house. They'd pat each other on the back and say, the system works. We found a lawyer that could speak somewhat intelligently. We found a judge that listened. We had grounds to bring the permit appeal. And we're not going to get that toxic waste incinerator in our community. Of course, what would happen next, 2 weeks, 3 weeks later, is that the corporations would come back. They'd fill in the gaps, omissions, and deficiencies that we had identified within the permit application. And in fact, we had got to a point where we had some of the lawyers for the largest corporations in the United States, like Chemical Waste Management, for example, who would come up to me afterwards and thank me for identifying the gaps, omissions, and deficiencies in the permit application, because then they could bill more to the corporation to actually fill in those places in the permit application that the corporation had missed. And so after a number of rounds of that, depending on how large the corporation is that you're taking on, I'm simplifying all this down, sometimes it was 6, 7, 10 rounds, that eventually the community group comes back to you and says, Mr. Linzey, we want you to do that jujitsu that you did the first time around and get this permit kicked out. And we had to look back at them and say, we're sorry, there's nothing we can do anymore. Because there's nothing in the regulations anymore that we can use as a lever. There's no gaps, omissions, or deficiencies left anymore. That, in a nutshell, is how environmental law is practiced today. That is environmental law. Some of the nasty little secrets of environmental law, of course, are environmental law is not built to stop anything. It's actually built to make sure that the project causes a little less harm by following those regulatory rules, and in essence, to regulate it so it causes a little less harm. And I think my awakening in many ways through doing these cases came when it seemed that there was a particular constituency, mostly liberals, liberal progressive types, who celebrated our win-loss record, this 302 or whatever we had on paper as a win-loss record, but didn't seem to care that if you went into the communities that we were representing, that there was absolutely no similarity between the communities themselves and the win-loss record that we had on paper, because those communities were getting shellacked. They were getting the toxic waste incinerator, they were getting the factory farm, they were getting the frack job, they were getting whatever project they were attempting to stop, because the permit regulatory system wasn't built to stop those things. And somebody back then said something that two things that resonate with me today. One is that we assumed that we just weren't strong enough, that we just weren't big enough to make the regulatory system work for us, that it was our fault, that we just didn't have the resources, we didn't have the personnel, we didn't have the energy, we didn't have all this other stuff. And then we learned that the monies, and we thought at least we were costing the corporations money, that the corporations had to hire lawyers to come in to fight us in the permit appeal process. It was then that we learned that the monies that the corporations spend on permit defense is tax deductible as a reasonable and necessary business expense under the law. So it's structural. There's a structural thumb on the scale. Meanwhile, the communities themselves had to carry their own financial burden, right? Because when you do file a permit appeal, you got to pay for it. And there's no way to get those monies back unless you can show, some kind of outrageous behavior by the agency, and that's rarely shown. So the thumb is on the scales of what's positive here, what's good, and how the system should function. And the other thing that's a bit deeper, which gets at some of the stuff that Cliff was talking about, is that somebody said back then that the only thing that environmental regulations regulate are environmentalists. Because they make us predictable as to how we fight when projects come in, because those regulations were written by the very corporations that ostensibly those regulations are supposed to regulate. And if we think the corporate boys who are actually trying to put projects in are going to build any safety valves in there for the communities to say no to them to come in, we're the insane people. That's insanity. If you think the corporations are going to write rules that voluntarily give power to the communities in which they're siting to physically stop them from coming in, that's nuts. That's crazy, right? It assumes this mythical world in which we live where unicorns are jumping over rainbows. It's just not the world, right? It's just nuts. But that's how environmental law has proceeded for the past 40 years. 40 years, that's how environmental law has been practiced underneath that regulatory structure, assuming that we can make it work for us. That's nuts. It took us 15 years, took us 12 years to figure out that it was nuts because we had hard heads. And we decided to switch gears. And we said to ourselves, if change isn't going to come from the state government or the federal government because they're so tied up and enmeshed with the corporate folks. I mean, a lot of times we talk about, corporations jumping, the people who work in corporations jumping the aisle into the regulatory agencies. And I think we see that a lot with the Trump administration, more so than maybe other administrations. We talk about that as being an issue, the personnel changing, the personnel being kind of the same. But there's even deeper issues there about the purpose of regulatory agencies. What's the purpose of the regulatory agency? And a lot of us think the purpose is to protect health, safety, and welfare. But maybe it's not. Maybe its purpose is to put a insulating layer between the people and the corporation attempting to put something in so that the agency becomes an interference level between the two. And so people come to us and they say, well, the regulatory system, we need to fix it, it's broken. To which we say, no, maybe it's working perfectly. Maybe it's working just the way it was intended. So we gave up hope on the state and federal level of government just because they're so intertwined with the corporate stuff. And in some ways, they're all part of the same corporate state kind of thing. The endless production of more stuff. I mean, that's kind of the underlying value that drives everything. And so we decided to switch gears and said to ourselves, okay, if the state and federal government is out of our reach, we don't have the power, we don't have the force necessary to make those things work for us, then maybe municipal governments, these sub-state governments, the counties, the towns, the villages, the townships, the places where we live, surely we have authority within those communities to make the kind of change that we need to make in terms of saying no to these harmful projects coming in. So we started working with those townships in rural Pennsylvania. So townships, small cities basically of 500, 1,000 people, sometimes less, 200 people, who were faced with huge factory hog farms coming into south central Pennsylvania. And long story short, the elected officials that we talked to in those early days, and we said, well, you guys need to do something here because the state and federal government's not going to help you. There's nobody that's going to help you do what you need to do to stop these things coming in. That the elected officials said, well, no, we can't ban X, Y, and Z here. We can't ban those factory farms here. That would be illegal to ban those factory farms coming in. And that was our first, up close and personal look at the rebar and the concrete about how the system is actually built. Because we look back at those elected officials and said, what do you mean? What do you mean when you say it's illegal to ban something at the local level? So we had to come to grips with the fact of the structure of law being in place. It's not that we sat back in an academic sense and said, oh, it's there and let's explore its basic parts. We had to run up against it individually in each of the places where we work. And so these community groups in those municipalities, just like East Boulder County United and the community groups that you have here that have been trying to use their elected officials and their municipal governments to move forward, started contacting us and asking us some really difficult questions, which basically shook our core all the way down. And it took, again, 15 years for us to go through the various processes and learn how the system works, apart from the myth of how we think it works. But the people calling us were no longer willing just for us to say, the system of law bans you from prohibiting legal uses in your community. They wanted to know why, right? Where does it come from? Why is it there? And so the first set of responses we had to them were fairly easy, which was we said, well, if you attempt to pass a one-paragraph ordinance, so let's say the city of Longmont passed a one-paragraph ordinance that banned all fracking within the community of Longmont. The first thing that would happen, as has happened in these different places, is that the corporations affected by the one-paragraph ordinance, they sue. They sue the municipality that passed the law. And they sue the municipality for violating the corporation's constitutional rights, right? It's usually the first claim in these lawsuits. And we've seen 50 of these things. They're all the same. The joke is we could go to work for the companies and boilerplate the thing on our computers because we've seen it so much. It's a script, okay? So keep in mind, a lot of our job is about seeing patterns. You know, so you hear the story about what happened in Lafayette and some of these other places, but it's all a pattern. It's about seeing those patterns to understand that it's structural. It's not just one place, it's not just one elected official, it's not just one bad apple, it's none of those things. It's actually that pattern or structure. And so people would say, well, why can't we just pass a one-paragraph ban on factory farms? And the answer is because you get sued, and the corporation comes in the door and they say, we are a corporation, we are a person under the law. So this concept, if people have heard of corporate personhood, that corporations are legal persons underneath the US Constitution. You know, this gets a little complex here, but you and I have Bill of Rights protections. We have free speech rights. We have a right against warrantless search and seizure. We have all these things guaranteed to us or secured to us by the Bill of Rights of the US Constitution. Well, back in the 1800s, corporations succeeded in getting the courts to say that corporations were persons too. So that corporations have those First Amendment rights and those Fourth Amendment rights and those Fifth Amendment rights. Why does it matter in this context? It matters in this context because the permit held by the corporation is property under the law. It's something that can be owned, sold, bought, bartered, transferred, whatever. It's actually property under the law. Why does that matter? The Fifth Amendment forbids government from taking property without compensation, okay? So that permit, which may look like just a piece of paper with ink on it, is actually a piece of property that can be sold. It's like your deed. You know, you transfer your deed. It's a piece of property. It represents that property. That property, when a local government passes a law that forbids the activity that is authorized by that permit, it's a takings of the corporation's property in violation of the Fifth Amendment to the US Constitution, okay? So it's a little complex. And so corporations, when they come in the door to sue your municipalities, when they pass this one-paragraph ordinance on banning whatever, the first claim you see is the corporation's asserting its corporate rights. That's one of the rebars in the concrete about how this system is built, is that corporations have certain rights. In addition to Bill of Rights protections, they have Commerce Clause protections. They're protected in their engaging of commerce under the Constitution, so they can also bring that claim against the municipality. In addition to that, dear to everyone's heart here is something called preemption, which is that corporations sue saying that the local government can't pass and couldn't pass the law that they passed because they're preempted by state or federal law. That means that there's a state or federal law that nullifies the local law because it does not give authority to the municipality to pass the law in the first place. Here, you have the Colorado Oil and Gas Act, which preempts any municipality from banning fracking and oil and gas extraction within the municipality. What's great about coming to Colorado is that in other states I have to prove that somehow. I have to go through, you know, the last 20 years about how the courts have ruled and what the interpretations are. You guys have real-time examples because the Colorado Supreme Court has overturned Longmont. and Lafayette and the other communities that have attempted to ban fracking oil and gas extraction within their community. I don't have to prove it to you. Just read the court decisions. You don't have to trust me. Just read the judges, right? Read the decisions about why preemption clears away your authority to actually ban oil and gas extraction. And the third concept that comes into play is something called Dillon's rule. It's the concept that municipalities, your town, county, village, township, whatever, only has the legislative power specifically given to it by the state legislature. That otherwise you have zero inherent lawmaking authority as a municipality unless it's given to you specifically by the state government. So in these cases, when you're watching the lawsuits come in, the first claim is corporate rights, you're violating the corporation's constitutional rights. The second claim is you're violating preemptive law because you don't have the power to pass what you're passing. And the third claim is Dillon's rule, which says you don't have the authority in the first place to pass what you've passed within the municipality. Those are the three claims that come in the door. Any fourth grader, any second year law student could draft the same complaint, mimeograph it. We don't have mimeograph machines anymore, but mimeograph it off. I use it because you got the mental picture of just like churning them out. That's what the lawyers do in these firms for the corporations. They just churn them out. It's nothing personal. They just churn them out because all they have to do is punch the buttons. The buttons have been built over the past 200 years to actually just punch the buttons and get the result, right? We don't have the same buttons to push because they've been taken away from us over the past 150 years. But those are the buttons that they push to sue these places. And it gets worse, which is that under a post-Civil War law, known as Section 1983, doesn't matter the number, but that corporations can sue your municipalities not only to overturn the law that's been passed, but to sue you for damages in the form of future lost profits. So in other words, as a municipal official, you're thinking nothing ventured, nothing gained. I just passed this ordinance. If we get sued, we have a municipal solicitor, we have insurance, we'll cover the cost, and the worst case scenario is it gets overturned. No. The worst case scenario is that the corporation sues you for $4 million for the loss of the gas resource that they can't access as a result of the law that you've passed, right? That's 1983, and it works in conjunction with the violation of the corporation's constitutional rights. So if the Constitution's civil rights are violated, it gives them automatic access to that statute, which allows them to recover financial damages from the municipality. And that's connected to another statute, which allows them to recover attorney's fees against the municipality. So if your community passes something, you're not just looking at having something overturned by the judge. You're also looking at a potential damage award against the municipality for the damage caused for not being able to access the resource. But you're also looking at a bill for attorney's fees to pay the lawyers for the corporation to sue you. To pay the corporation's lawyers to sue you, right? So talk about debt shifting, right? It's all about risk shifting and debt shifting onto those least able to do anything about it, which is our municipalities, our communities. And so these phone calls that came in would say, why can't we? And we'd explain why they can't. And on the corporate rights stuff, they'd say, why? Why do corporations have these constitutional rights, right? And we'd say, we're so happy you asked, because we know the answer to that one. And the answer is that back in the 1800s, the courts began giving corporations constitutional rights. So it happened very slowly in the beginning. It was just something called the Contracts Clause. Then it became the First Amendment, then the Fourth Amendment. People may have heard of the Hobby Lobby decision, which recognized that corporations can have religious beliefs under the Constitution. You've heard of the Citizens United decision, which struck down campaign finance legislation on the basis of corporate First Amendment free speech rights. In other words, this isn't some romantic, abstract thing that corporations have corporate personhood rights. They're actually used. It's where the rubber hits the road. And the rubber hits the road most of the time, the majority of the time, on you. You become the road. They're the rubber. And that's where it hits, is when these things come into play. So we would say, well, corporate rights go back to the 1800s, and courts gave corporations constitutional rights. And the folks on the other end of the line would say, why? Why do corporations have constitutional rights, right? And we would say, well, it's because we operate within a U.S. constitutional structure that's about elevating the rights of property and commerce above the rights of people, communities, and nature. That the US Constitution, leaving aside the Bill of Rights, which, by the way, had to be driven in by a revolt, by folks refusing to ratify the Constitution without a Bill of Rights. So the text of the US Constitution is very clear. It's about elevating certain rights over others. And if corporations, which became the dominant actors in property and commerce after the Civil War especially, became those dominant actors, it makes no sense to protect certain rights and values in the text, but not confer those rights and values on the corporations themselves, who are the predominant actors in carrying out those property and commerce activities under the Constitution. So we would talk to folks in the community about that, and they would say, why? Why does the US Constitution protect property and commerce? And we'd say, well, we'll take a stab at it. We don't really know why, but here's our thoughts on that, which is that the US Constitution was written in the 1780s. And the 1780s, the mindset by the founding fathers was that we had resources that needed to be exploited across the land, that to become a powerful nation and not continually invaded by England, re the War of 1812 and everything that happened afterwards, that to become a powerful enough nation, both economically and defensively and to protect ourselves and everything else, that we had this massive amount of raw materials that needed to be exploited and made into usable items of commerce. And so they wrote a constitutional structure that did exactly that. It's worked very well from that mindset. They didn't know anything about ocean acidification or frack well leaks through concrete casing or endangered species or climate change. They didn't know any of those things. We have a 1780s DNA. The DNA, the constitutional DNA of this country, is from the 18th century, right? The text of it, the structural stuff of it. And it's not open to communities having authority to protect themselves against dangerous things that come into those communities. So we would say to the folks on the other end of the line, right? And if they hadn't hung up yet, they would say, well, why is that? Why does the Constitution embody those values? And we said, well, it's because the US Constitution borrowed stuff from English common law. English common law, which developed in the worst part of the colonization era of the world, where England and Portugal and France and the other colonizing nations were going into the Caribbean and basically superseding their structures of culture and law with England's, and about England taking a structure of law and superseding it onto those places. That's where English common law came from. It was about violence, it was about racism, it was about all the bad, really bad stuff. But our lawyers who gave birth to the Constitution, who wrote the Constitution, they thought English common law was the best thing since sliced bread. So if you read the Constitutional Convention and Alexander Hamilton stands up and he says, we know, everyone in this room knows that England has the best source of law ever invented on the globe. I mean, those are the kind of speeches that were being given in constitutional halls. They were drafting the Constitution, right? And so people on the other end of the line would say, well, why is that? Why do we borrow English common law? We say, we have no idea, right? I mean, that's about as far back as we go. But all to say is that the stuff that you see today is like the iceberg. And the rule on the iceberg is that 20% of it's above the water and 80% of it is below. And our activism sometimes only sees the 20%. And we say, all we have to do is elect somebody new, somebody good. We just need to elect somebody good to the city council and everything will change. Or we just need to appeal this permit in a creative way. Or we just need to tweak the regulations to make them better. Or we need to make it so, this is my favorite one, we need to make it so expensive that nobody comes in here, right? Well, don't you think the corporations thought of that? In fact, they thought of that 80 years ago. And there's a line of cases where if you make it too expensive, it's treated by the courts as a ban, because that's what it is. And you get the exact same lawsuit. And the lawsuit says you're violating our corporate rights and you're preempted and there's Dillon's rule. I mean, how stupid are we, right? I mean, in some ways. We've been trained to be stupid in some ways. But the key is to understand that it's what you don't see that kills you, right? It's what you don't see. And it's also not what the corporations are doing illegally. That's the problem. It's what the corporations are doing legally. That's the problem, right? And that puts us sometimes in a completely new and different brain space. So it's still amazing to me, I'm going to finish up here because doing a lot of talking. It's still strange to me that what started in rural Pennsylvania, in a little community of 500 people, 500 people in a community who stood up and said, fuck you to the factory farm corporations coming into South Central Pennsylvania, said, we don't care that we're going to get sued. We don't care that you're going to bankrupt our community, right? We know that there's no other option. We know that the other doors are closed. We know if we work through the regulatory structure, we're going to get a better factory farm, right? A factory farm with less fly swarms, right? That's some of the conversation that was happening in the environmental groups when we came in 15 years ago. You know, do we just need to limit the odor and the fly swarms and everything will be okay? Well, it's not okay. When you put in a factory farm, you're eliminating family farmers because you're putting in a corporate structure of farming. And we've lost 300,000 farmers in the last 20 years. And you know, you could go on and on with these statistics about what the actual problem is. The problem with, you know, frack wells is not air pollution and the other things that come from it. It's the fact that you're taking shit out of the ground and you're combusting it, which eventually is cooking the planet. That's the problem, right? That's the problem that you can't fix. You can throw however much money you want at that problem. You can't fix it. Air pollution, those types of things, corporations can fix those. I mean, they can put money in it to fix those. So anyway, what Cliff outlined here, what's happened in this trajectory, is the exact identical experience of other places. And the only other story I want to tell here, because I think it has direct relevance to what you guys are doing, is Spokane, which has been my home for the past 5 years. And in Spokane, Washington, folks came together and said we have to do something about the coal and oil trains coming through the city. Spokane is situated in a place where all the coal coming out of the Powder River Basin, all the coal moving to the West Coast, comes through one bridge in the city of Spokane. One bridge, right? And people in Spokane said, basically, if we don't take steps to stop that coal and oil coming through, we are co-conspirators to the whole thing. We are basically involuntary or voluntary by silence. Our silence is assent. That we are co-conspirators to this climate change catastrophe that we are now well underway on. And so they decided to draft a climate bill of rights, which was modeled after Lafayette's bill, the legislative measure that was championed by Cliff's mother on the Lafayette City Council. We took that, modeled it as a template, and sent it to the City Council of Spokane. The City Council of Spokane voted to put it on the ballot directly. They looked at it and said, this makes a lot of sense. It had the direct action stuff in it that's become so controversial here, that in essence, that if the city didn't enforce the law, that direct action could be used by people within the city to directly enforce the law without fear of law enforcement coming in and arresting them. What the law did was ban fossil fuel shipments as a violation of the right to climate. People have a right to climate, and the ban on fossil fuel shipments was necessary to that right. City Council looked at it, not particularly the most progressive City Council, and voted to put it directly on the ballot. The railroad companies then put pressure on the council and said, we're going to sue you if you allow this to go on the ballot. And we're going to sue you because you're interfering with, guess what, our corporate rights. You're preempted by the Interstate Commerce Commission Termination Act, the ICCTA, which is the federal law that takes all local authority away from regulation over the railroads. And Dillon's rule kicks in because you don't have authority as a municipality to pass this in the first place because the state legislature has never given it to you. President of the City Council, the main leading liberal Democrat in the city of Spokane, stands up and gives a speech that we need to take it off the ballot because we can't risk a lawsuit from the railroad corporations. Gets enough of the liberal Democrats to go along with him, they take it off the ballot. The next step was the people, us, who proposed it in the first place, have now taken it, converted it into an initiative. The petitions were printed 3 weeks ago, and now we're moving to qualify the initiative directly through the citizens process. Last time we did that in Spokane, Chamber of Commerce and the corporations there sued to keep the initiative off because now there's a huge new area of, believe it or not, pre-election ballot challenge litigation in which corporations are taking stuff off the ballot preemptively before it even gets to a vote because they understand how dangerous it is once you vote on it. Because once you vote on it and approve it, they have to go to court to nullify it. But if they can kill it before it even gets to the ballot box, that's the direction that they're heading. In Colorado, that case law is starting to build. It's not as bad as other places, but it's headed in that direction. And so in Spokane, understanding that the legislative stuff was limited as well, a group was created called Direct Action Spokane. And last year, they had the first 9 people arrested on the tracks. Successive groups of 3 people who actually stopped the railroad traffic for about 5.5 hours coming through the city of Spokane. They're going to trial in April and May. But all to say, people in Spokane and other communities, and we work with about 300 communities across a 20-state region now, including some of the tribal nations who are beginning to contact us because they have greater leeway of lawmaking. Not much, but a little greater leeway of lawmaking than the municipal governments that we've been working with over the years. That those places are all feeling the same thing that you're feeling and understand that we are to a point where we have exhausted all imagined remedies. That in our heads, we think we live in a democracy. And in a democracy, there's a remedy for every harm that gets caused. It's been inculcated in us since kindergarten that we live in a democracy and there must be some avenue of legal change that we can make to stop what's threatening to harm us. But in reality, we don't live in a democracy. It's a corporate state. It's a place in which the structure has been predetermined for us. And so we have to start coloring outside the box. And part of this Lafayette piece of legislation about the direct action civil disobedience was about doing just that, which was moving outside the box and understanding that our activism needs to be commensurate with the problems that we face today. And our activism today, especially in liberal circles, is not. And in fact, I'll leave with this thought, which is we refuse to work with conventional environmental groups anymore. We work with the grassroots environmental organizations, but the big environmental groups are just as bad as the corporations that we try to stop in our communities because people think of them as allies, when in reality they're sending people down the regulatory chute. They're going down the better regulation, they're getting down the permit appeal stuff, and they're actually removing the ability of communities to move on their own. What we think needs to happen is a revolution of 10,000 communities who stand up and say, screw you, we're not doing this anymore, and we're going to build a new system of law. And in support of that, we've put together a legal doctrine, the right of local community self-government. We submitted a law review article to give it some gravitas, but eventually it says you have a right within your community to expand civil and political and environmental rights out at the community level above and beyond what the state and federal constitutions provide. And that may sound radical at first because we can't get our brains around local bills of rights. In other words, we don't necessarily think of our cities, towns, villages, and counties in that manner. But it's actually not radical at all because for the past 70 years, the courts in the United States have recognized that state governments can expand political, civil, and environmental rights out beyond the federal minimum. So the federal Bill of Rights is a floor, and states can build on top of that floor. What we're arguing in the courts and also in the constitutional amendment processes, which are moving in several states, is that we need to take that same relationship and apply it to the local versus the state and the federal. That local can expand out civil, political, and environmental rights above those offered by the state and federal floor. And that's where we're headed. But we don't have faith that the courts are actually going to embrace that anytime soon. And so we're working with other state networks like the Colorado Community Rights Network to move forward state constitutional amendments, which would actually change the constitutional structure of law to get at some of these rebars that have been set in the concrete for the last 150 years, which stop you and stop me and other people in other communities from stopping that which threatens to harm them.